Good morning. I want to give some tips to you about how to conduct yourself in a deposition. These tips are generally good for any type of deposition in a court case. Specifically, though, from my practice, which is limited to representing people who are injured due to the fault of another, these tips are may have some focus on injury cases. First, let's start with what a deposition is. I should note that the general commentary I'm making is specific to the state of Connecticut. It may vary in other states, and it may be called something different in other states. In Connecticut, a deposition is basically a question and answer session that is done under oath. What does that mean? Typically, it is done in one of the attorney's office after a lawsuit has been started. Present in the room would be the person whose deposition is being taken. That is the person who is being asked the questions. We sometimes refer to her or him as a deponent. The person who takes the deposition or asks the questions is always the lawyer who initiated the process to take the deposition. In almost all cases, it is the opposing attorney on the other side. There are some rare cases where I would take the deposition of my own client, but that is, as I said, rare. That's not to say that I will not take depositions. I do. In representing my client, I will take depositions of the other party or other witnesses, doctors, etc. So in this case, or in a case, a car crash case, the driver who we are alleging caused the car crash has an attorney. That driver is being sued in court, and that attorney for that driver represents that driver and will take the deposition. So if you are the person who's being asked the questions, you're the deponent, and the attorney will ask you questions. Now, present would be, of course, myself, my client, the person who's being asked the questions, the lawyer for the other party, on rare occasions, the other party, a court reporter, that is a person who will type down word for word all of the questions and all of the answers to create a transcript. We'll talk about that more in a second. And in the case of a person who is deaf, an American Sign Language interpreter. In other cases where the person is a non-native English speaker and prefers to be asked the questions and to answer the questions in their native language, we would have an interpreter, for example. It is common to have a Spanish interpreter for our Spanish-speaking clients. One of the things that is very important for a person taking part in a deposition where there is an interpreter is to be patient. Because as you can see now from the screen, I am asking the questions, and I am asking them a little bit more slowly than I might if I wasn't using an interpreter. And the interpreter is interpreting, in this case, in real time, my words so you can understand them. It is important, if you have some ability to hear or read lips, that you only pay attention to the interpreter while I am asking the questions, or the other attorney is asking the questions, I should say. Because even though you may understand part of what the question is from either some hearing ability or ability to read lips, you want to make sure you understand the question completely, and that is best facilitated by using the interpreter. And so that does slow things down sometimes if you think you understand part of the question before hearing the question. But even for folks who don't require an interpreter, my advice is always make sure the other person is done speaking, you understand the question, you think about what your response is before you give an answer. And likewise, we will wait for you to answer the question in the case of an ASL interpreter. And the interpreter then speaks your words to us to make sure we have everything down. If for some reason there's a communication issue between you and the interpreter, you need to let me know right away. Likewise, obviously, if the interpreter feels that one party is speaking too fast or interrupting, the interpreter should let us know as well. Because the number one most important thing in a deposition is to make sure that when you say something, that it is exactly what you meant to say. And so that brings me to this one point, which is in a deposition, some lawyers tend to give advice that I feel is not conducive to getting your truth out. And that's important to understand when I say getting your truth out. And sometimes you'll hear a lawyer or me say, get your testimony out or your story or answer to a question. But in all cases, it's your truth. And what I mean by that is at the beginning of the deposition in the room, you will be administered an oath by the court reporter who will ask you that basically that your answers will be the truth and nothing but the truth. It is very important that you always tell the truth. Now, this is not meant to insult or offend you or anyone who might be watching this video. I'd like to think that people don't intentionally lie, but sometimes they do. So my advice is to not lie. Number one, you're under oath, and it is potentially a crime to lie under oath in court. And this deposition, while it won't be in the courtroom, is part of a court proceeding. And that's important also to understand that while the deposition is in a lawyer's office and not in court, the deposition could be used in court, including at trial. And so we want to make sure that you're always being honest. Now, what if you don't remember something or you're not sure? That's perfectly fine. Happens all the time. Oftentimes the deposition is taken many months, sometimes years after an incident happened, and people's recollection isn't as good as it was when it happened. So it's important then to make sure you say something like, I don't remember, or I'm not sure. It's okay if you estimate something, but there's a difference between estimating and guessing. And that's where it gets a little weird sometimes. We don't ever want you to guess. If you understand the question and you're able to recall an answer that's truthful, please give it. On the other hand, if you don't know, it is very bad to guess, to use logic or common sense, say, well, it must have been this. That's not testifying truthfully. That you may not think that's a lie, but that's basically you making up an answer that you think makes sense. So I don't want to belabor this point by continuing to talk about this, but you can see this is an important thing. That's why I'm talking about it. Many cases have been jeopardized and sometimes ruined because a client has either intentionally lied and gotten caught in the lie at some point in the case, or has just guessed at an answer or sort of inserted an answer that really they didn't remember, but they thought helped their case. And while that may not seem like a lie, that it's just as bad. So don't do that. It's part of the reason why we do deposition preparation, is to give you an opportunity to think about the questions that may be asked to you, to think about the facts of the case that you're here to talk about, to review any documents that you are that are part of your case to help refresh your recollection, and of course to consult with me to help you understand anything that you may not understand. So when you take that oath, raise your right hand and swear to tell the truth at the beginning of the case. You must. Now, the second thing is make sure you understand the question. There is no shame if you don't understand a word, if you don't understand a question. Oftentimes lawyers ask questions that are confusing, and not necessarily on purpose, but just because there's a lot the lawyer's thinking about, and she or he may be asking a sort of awkward question. So if you don't understand the question, it's perfectly okay to say, I'm sorry, I don't understand. Can you please rephrase that in a different way? Similarly, if there's a word or a term a lawyer uses, it could be a medical term, some other type of term or word, you should say, I don't understand that word or that term. Can you please tell me what it means or ask it a different way? And I can tell you a quick story to sort of illustrate that point. I had a client. She was a certified nursing assistant, CNA, and she had an incident where her back was injured as part of the lawsuit that we had brought. And the lawyer was asking her a lot of questions about her back injury, and the anatomy of her back. And he was using some medical terms which are common to lawyers and even maybe some lay people, such as herniated disc, and other orthopedic type terms. I assumed, based on my clients answering the questions, that she understood, and the fact that she was a certified nurse's assistant, and the fact that she had hurt her back and seemed to have a good understanding of her back injury, that she understood the questions. But it appeared to me after a few minutes of her speaking and me knowing my client a little bit, that she really wasn't sure what he was asking her. So we took a break. We went into a private room. And I said to her, you seem a little bit off, maybe confused. Do you understand the questions he's asking? She said, Jim, I don't know what those words mean. So I said, okay, that's all right. But why did you answer the question? Because she had answered maybe 5 or 6 questions when he had used some words she didn't understand. And she said, well, I'm embarrassed because I'm in the medical profession and I should know what those words mean. So of course, I had to explain to her she shouldn't be embarrassed. And all of us, there are things all of us, lawyers, doctors, everybody don't know. We don't know everything. And so we were able to go back in the room, and she was able to tell the attorney, I answered a few questions that I really didn't quite understand. Can we please go back and ask those questions again? And the lawyer was happy to do it, and we cleared it up. And that's two things I want to take away from that story. The first is, you can take a break at any time you want during the deposition. I find, especially when an interpreter is involved, it can be mentally taxing on your brain, and people need breaks. So this is okay. Anytime you need a break, for whatever reason, you don't even have to give the reason. Just ask. The only caveat to that, or condition, is that you can't ask for a break in the middle of a question. So if the lawyer asks you a question, you have to finish answering the question and take a break. They don't want people to take a break, go talk to their lawyer in private, get an answer from the lawyer, and then come back and give that answer. So number one, you can ask for a break at any point. And that's one of the lessons, the takeaways from the story I just told you, which is it's okay to take a break. In that case, I noticed something was off with my client and I asked for the break. But there are times where you're going to need to be your own self-advocate, because I may not know that you need a break or that you're struggling with something. So you'll need to do that. The other thing is, the other takeaway, of course, is you should never guess. Don't be embarrassed if you don't know what a word means. This is not the time to do it, because had we not caught that, her answers would have then been inconsistent with what the record showed. And they would have used that, number one, in evaluating the case, because they would have thought she was just lying. And number two, they might not have told me that. The case might have had to go to trial, and then they would have used that against her at trial and made her look bad. And once you get caught with inconsistent testimony in front of a jury, it's very difficult to convince them it was an honest mistake, because they figure, the jury figures, hey, you were in your lawyer's office, you had a chance to talk to your lawyer, you could have taken a break at any time. The lawyer gives instructions at the beginning saying, if you need a break, please ask for one. If you need to talk to your lawyer, please ask to talk to him. If you don't understand a question, please ask us to rephrase it. This is standard in every deposition. So if you don't do those things and then later on try to backtrack on an answer, they're going to say, well, wait a second. Didn't we tell you if you didn't understand a question, ask us to repeat it? Of course, you would say yes. Didn't we tell you that you have a right to talk to your attorney at any point during the deposition? Of course, you would say yes. Didn't we tell you that you could take a break at any time for any reason, to include talking to your lawyer? Yes. And so what happens is it then just looks like maybe you're not telling the truth, even if you made an innocent mistake. So those are the takeaways from that story. Now, some lawyers, if you were to go online and watch videos of other lawyers giving deposition tips, would say, just answer the question yes or no, if you can answer the question yes or no. While that's not bad advice, and there may be a perfect time to answer a question just yes or no if it calls for a yes or no answer, I don't limit my clients when they give an answer. It's not my deposition, it's yours. What I mean by that is, of course, if someone says, is your name Joe Smith, for example, and your name is Joe Smith, of course you could say yes. On the other hand, maybe your name is Joseph Smith. So you might want to say, well, technically my name is Joseph Smith, but people call me Joe Smith. And we could give example after example of situations where a yes or no may be appropriate. The reason I don't give that advice, generally speaking, to my clients in injury cases is because this is really the first time the lawyer, and by extension, the insurance company that's paying for the lawyer for the person who caused the incident, gets a chance to see you. There are tens of thousands of active lawsuits for injury cases, whether they're fall downs, work injuries, car crashes, etc. And everything up until the point of your deposition is done on paper. Medical records, medical bills, photographs, police reports, witness statements, things of this nature. It's very sterile. What I mean by that is, to the insurance company, and by extension to their lawyer for the at-fault person, you're just a name and a person making a claim. And these insurance companies have become jaded over the years, cynical over the years, but everybody who's injured, or let me say it a different way, everybody who's been in an incident who has a lawyer is just trying to get money, just trying to get paid. They're not really that hurt. And so that's sort of their mindset going into the deposition. And while, of course, there are exceptions to that based on serious traumatic injuries with gruesome pictures and clear objective medical evidence, there are a whole bunch of cases. In fact, the majority of cases don't involve those types of facts where the pictures take your breath away, or the person lost a limb or needed surgery or was out of work for a year. serious cases, but compared to that, they're much less serious. And so insurance companies become very cynical, very jaded. And what happens is they are seeing you for the first time. So let's talk about what they see. Obviously, with COVID, we have become very used to doing things on video. And so there are some subtly different rules for video. You can see right now from this recording, the interpreter and I have a very neutral background. I'm sure both of our backgrounds are perfectly fine, but they're not distracting, this neutral background. And so on video, I've had people do the deposition in a room of their house, but in the background, there are things that are distracting. So I always like to pick a neutral room with a neutral backdrop if we're doing it by video. So if we do a deposition by video in my office, we always use a neutral wall background or a screen like I have, or like the court reporter has. Now, how do we dress? Well, for a deposition, I'll typically, even though I won't be on camera, I'll typically be a little more formally dressed with a jacket and a tie, or at least a jacket, a shirt, a suit shirt. I tell my clients who will be on camera for a video deposition to dress in a manner they're comfortable, but not too comfortable. I always like to say, if you're going for a job interview, how would you dress? So you don't want to dress like some of my clients in the past have come. Sometimes we'll do literally a dress rehearsal. I'll say, I want you to come to my office and we're going to practice some questions for your deposition. I want you to, and I don't give them any instruction on how to dress. Come dressed like you're going to be for your deposition. And I've had folks come in dressed like they're going to a nightclub, which is kind of inappropriate for a deposition, or coming right from work, dirty and messy. And again, I appreciate hardworking people. Again, inappropriate for deposition. So I always like to say, you want to dress, you don't have to wear a suit and a tie or a dress or something super formal if you don't own those type of clothes, or if wearing those type of clothes makes you uncomfortable. But you should wear nice clothes like you're going to a job interview, and the same clothes you would wear going to court. Because remember, this is the first time the attorney is going to meet you, and you want to make a good impression. I understand just judging someone by the way they look is unfair and often inaccurate, but that's still human nature to judge someone. First impressions do count. And particularly for those of my clients who are deaf or hearing impaired, appearance then becomes even more important because their ability to speak using words is not part of the evaluation process. In person, it's the same thing. You just want to dress appropriately, not basically like you're going for a job interview, like you would wear to court, not too flashy. If you're a person who wears a lot of jewelry, I would tell you to tone it down. For men, I wouldn't dress wearing super tight clothes. That same advice actually for women. Common sense, I think, for most people, but you'd be surprised of some of the things folks have done in the past, which is why I spent a few minutes talking about it now. So we've talked about taking the oath, telling the truth, making sure you understand the question. Understanding I don't want you to say yes or no if you have more to say. And there are plenty of questions you'll be asked where you can have more to say. Now, you have to be careful to not ramble. And for example, now I'm speaking, now I'm just speaking. So I'm trying not to ramble. I'm trying to be focused on the purpose of today, which is to give some general deposition advice. In a deposition, it's way more controlled. The attorney is going to ask questions. So if you start to get too far away from the question with your answer, some attorneys will let you talk, because we learned as attorneys, when you let a client talk in a deposition, they may end up saying something that hurts their case. That's the danger with rambling, with just sort of talking for the sake of talking. But I do not want you to think for 1 second that you should not answer the question in a way that you feel comfortable telling your story. It's your story. This is your one shot, your time to be heard. The way the attorney views you is important because she or he is going to write a report to the insurance company that will accompany the transcript. Remember, the transcript is a word for word recitation of all of the questions and all of the answers. And the attorney is for sure judging you in part on whether you make a good appearance, whether you're polite, respectful, patient, listen to the question and gave a thoughtful response, versus the opposite: impolite, impatient, interrupting, not giving thoughtful responses, arguing, getting angry, lying, exaggerating. These are all things the other attorney is looking for. They're not necessarily trying to get you to do any of those things. People will do them on their own for different reasons. Now, hopefully after watching this video and having an opportunity to prepare for your deposition properly, you won't do those things. Because really, if we had to end this video right now, I've given you all the general advice that you need. How to dress. Make sure you listen, understand the question, and give a thoughtful response. This is your truth, and I want you to tell it. Now, there are a few areas where I want you to really, really think, and this requires you to do some homework on your behalf. This is not something that I can help you do. You have an opportunity to review your medical records and have someone help you if you need help interpreting the records. And what I mean by that is if your ability to read is impacted. Because it's important to make sure you refresh your recollection as to what you told the doctors when. And I can tell you, I promise you that it's very difficult to remember what you told the doctor years ago. Now, I want to be clear. I'm not suggesting you memorize anything. That's what the records are for. You don't need to memorize the dates, the specific things you said, but it is important to have a general memory. I've had cases, I'll give you what seems like a stupid example, but it's the truth. I've had clients talk about their shoulder, for example. This one particular client had a shoulder problem, just touched my right shoulder. And he was talking about his shoulder and he kept referring to his right. He didn't say right, he kept touching his shoulder, just like I'm doing now in the deposition, touching it. I'm noticing this because I'm sitting right next to him, but he's not saying my right shoulder. He's just saying my shoulder and then he's touching it. Now, I know that I have the records and I can see that it's his left shoulder. Left shoulder that he complained about from day one, it's the left shoulder that all the records support, but he kept doing this. So at some point, the other lawyer says to him, and remember, the other lawyer is asking the questions. And this is a good point for me to interject. During your deposition, the lawyer for the person, the deponent, the person being asked the questions, isn't permitted to give advice or object to most questions because there's no judge there to rule on the objection. The only objections that a lawyer can make in a deposition are what we call objections to the form of the question. I'll give you a simple, easy example of such an objection. Is your name Joe Smith and is your favorite color red? Well, that's a stupid example, but it's shows you what would be a proper objection to the form, because you can answer yes or no to one of those questions or both of those questions, but it's possible that your name is Joe Smith and your favorite color isn't red. So when lawyers, usually by accident because they're asking a sloppy question, put two questions into one, that's an objection as to form, because the client might just say yes, but yes may only be proper for one of the two questions. So we're going to talk in a second about the things that they can ask you in a deposition. But I want just to be clear when you're answering the question, your lawyer, the lawyer of the person being asked the questions, almost never says anything. I'll typically be reviewing records in the area where the questions are being asked, making some notes, perhaps making some follow-up questions, because I do have an opportunity to ask follow-up questions when that lawyer is done. We'll talk about that in a little bit later. But I'm generally not doing anything but sitting next to my client at the deposition. And I don't want, and you should never feel off put by that. Like, geez, what's my lawyer doing? Remember, this is a question and answer session under oath. The other lawyer asks the questions. That's their job. Your job is to answer them. Your lawyer's job is to make sure that they don't ask any improper questions. And so if I don't object, that means the question is proper and that you should answer it if you can, understanding the rule we talked about already, which is if you don't understand the question, you should ask them to rephrase it or repeat it or ask it a different way. Things the lawyer can ask you. Well, in Connecticut, almost anything, with the exception of questions that would be deemed harassment. So they will always ask, most lawyers will almost always ask what I call background and biographical type questions. Where you were born, raised, your parents, siblings. They may ask what your parents' names are, whether they're still alive, what did they do for a living. They may ask those same types of questions about your siblings. They will ask you your education level, highest level education. They'll ask you places that you've lived. They'll ask you about your job history. And some clients don't like these types of questions. They become, and we talk about it in advance, they well, why does that matter? How is that relevant? Remember, I told you, they can almost ask anything with the exception of harassing questions. And while those may seem harassing to you, they're generally accepted in Connecticut. So you just have to answer them. Part of what they do in a deposition is they just want to sort of see how you are. Folks that get angry or nervous about answering those types of background questions, that's a red flag. Like, well, geez, why does this person not want to tell us that? Some of the areas where it gets a little weird sometimes is when folks have been divorced, they'll say, are you married now? Have you ever been married before? Of course, if you've been married more than once, they'll ask you some basic questions about your prior marriage, and that's sometimes a sensitive subject. So if there are things, by the way, that you're concerned about or worried about, things that are sensitive, you should always let your lawyer know that before the deposition. Here are the things that I'm worried about. Here are the things that I'm concerned about. Here are my questions. Because that's the kind of thing that you would do in advance of the deposition to prepare. So when you go into that deposition, you feel ready, almost like wearing a suit of armor. You're putting that suit of armor on you to protect you. And you have the confidence to know that these are the types of questions they're going to ask, and I'm just going to answer them, and I'm going to tell the truth. And you feel good about it. So that's part of the preparation process. If you do have things that you're worried about, concerned about, you need to ask your lawyer in advance. Once the lawyer is done asking the questions, I'm given an opportunity to ask questions myself. I would say 80% of the time, 8 out of 10 times, I don't. And the reason for that is because I feel that my client did a satisfactory job. And there's nothing I really need to add to it. Now, if I have to ask a lot of questions, it means that there's some areas that need to be cleaned up. Maybe some confusion in the way you answered the question, or something that needs to be better explained. Oftentimes, I'll take a break and say, hey, look, there's about 4 or 5 questions I'm going to ask you in this area because I feel that maybe we can do some further clarification. At that point, if you feel uncomfortable about it, that's the time to discuss it with me. But generally speaking, I would say 8 out of 10 times, I don't ask any questions. And if I do ask questions, it's generally a handful of times. And that's because the client is prepared. They've thought through all the issues ahead of time. They've reviewed the police report. They've reviewed photographs. They've reviewed their medical records. And you'll be asked that question. Did you review anything prior to today's deposition? And the answer is, if you did, is yes. And if they ask you what, the answer is whatever it is you reviewed. Our conversation is confidential. What we talk about, they cannot ask you about, and they almost never ask. They don't. In fact, I don't remember the last time a lawyer tried to breach attorney-client privilege by asking those questions. What you reviewed in terms of papers, the police report or photographs, your interrogatory responses, those are the questions that we helped you prepare, your medical records. If you reviewed that, which is perfectly normal and you should, and you're asked the question, what did you review? You would just say that's what you reviewed. I would tell you though, if you only skimmed those things, if you only did a cursory review, a brief review, you need to say that. Because if you say you reviewed everything and then later you say, I don't remember, the lawyer's going to say, I thought you reviewed everything. So you could say, I did a quick review or a cursory review, or I skimmed my medical records, if that's what you did. If you read them more closely and more carefully, then you don't need to put any qualifier on it. But the reason you want to look at your medical records, particularly in the is not for the medical terms, but there's in every medical record, there's a section where you told your doctor something, how you were feeling that day, what you were complaining about that day, what specifically bothered you. And that's an area where you need to refresh your recollection. In the case I gave you where my client kept touching his right shoulder and it was his left shoulder, the lawyer finally asked him, you keep touching your right shoulder, sir. Which shoulder was it that was hurt? And it was like a light bulb went off on my client's head. He goes, oh, my left shoulder. I should have been touching my left shoulder. And I don't think anyone thought he was lying. I just think for whatever reason, he was doing this instead of this. But that's important to have a handle on that. So things you should review in a car crash case, the police report. You want to pay attention to the obvious things on the police report, like the date and the time and the place and the weather. Then you want to pay attention to, of course, the narrative section in the diagram where it talks about what the police officer was told. Obviously, unless you have direct evidence of what the other person said, because you heard it or you were able to read lips or something like that, you can't speak to things you don't know. But if there's something in there specific to you, you have to make sure that it's accurate. There's questions about the force of the crash. It's very important. This is where I tell my clients, you need to elaborate, but not exaggerate. And what I mean by that is every client who's hurt will say, just about every client who's hurt will say that they have pain. That is virtually meaningless. You have to be able to describe the things that happen to you more articulately. And sometimes that can be a challenge, whether you're speaking in ASL, using ASL, or just speaking in English. But it's important, for example, when we talk about the force of the crash, to quantify it in some manner. I always use the story of Goldilocks and the Three Bears, where one bear said it was too hard, and one bear said it was too soft, and one bear said it was just right. Well, you got to do something a little bit more sophisticated than that, but some level of degree. Pain, for example, can be described in maybe an almost limitless way. Pain can be sharp. It can be stabbing. It can be dull. It can be numbing. It can be tingling. It can be distracting. And I can go on and on, but I won't. You need to think about how your pain was. And it's not always the same from day one to today. Oftentimes it gets better, it gets worse, fluctuates. But these are the questions that are critical to telling your story. And what I mean by this is, I want you to picture an onion or an orange. We'll start with the onion. When you peel an onion, you take off that first layer, and you can continue to take layer after layer after layer off until you get to the middle and there's nothing left. Same with an orange. Starts off big, plump, juicy until you squeeze it, and get all that juice out. Whichever one of those metaphors works for you, I want you to think about in answering questions. For sure, there are some questions you can answer just yes or no, or that require a much shorter response. But there are other questions where you're going to need to peel that onion or squeeze that orange juice. These are the questions that I cannot answer. I have the medical records. I know what you complained of to the doctor. So does the other lawyer. We know what the doctor said. So does the other lawyer. We know what the medical bills are. That's stuff we don't need you for. We need you to show us how this affected your life, how it impacted you. And this is hard. And this requires you to really spend some time thinking about it, because for something that happened years ago, number one, your memory has faded. Unless you have a photographic memory, which almost no one has. And number two, pain is one of those things that we tend to forget in a way that's persuasive. For example, every woman that I've ever spoken to that has had a baby describes this as the worst pain ever. But yet, why do women have more than one baby? Because the body tricks itself to forget the pain. I mean, you know you had pain, but your body doesn't let you relive that pain, because if it did, you would never ever have another baby. So I'll typically ask a question to my clients in depo preparation, something like, have you ever stubbed your toe before? Of course, almost everybody says yes. And then I say, describe to me how it felt. And I swear to God, 100% of the people I ask that question to, they smile or laugh. Now, you know they weren't smiling or laughing when they stubbed their toe. So why are they doing it now? It's bizarre. Something about the way the mind makes you forget pain. You know that was painful. You know it was terrible pain. So I think you get the point. So you really have to think back to what it was like and understand that sometimes your pain is worse in the beginning and gets better, or it changes, somehow morphs into a different kind of pain. And that's why we look at the medical records, because they will help you remember a little bit better what you were complaining of years ago. Sometimes people use that simple scale 0 to 10. They'll tell a doctor their pain is a 1 or a 2 or a 5 or whatever the number is. And lawyers like to ask that question. Do you remember on a scale of 1 to 10 or 0 to 10, 10 being the worst pain ever, 0 being no pain at all, what your pain was like when you went to that doctor at the beginning? This is one of those questions where you can't guess. You either remembered what you told the doctor or you don't. Or if you're really sure, but you're not 100% sure, you could say somewhere between a 6 and an 8. Well, what I would tell you now is you better make sure it was a 6, 7, or an 8. Because if it was off by a lot, all your testimony now just becomes less credible. This is a good example of something where you're not intentionally lying. And you're thinking, what was my pain on a scale of 0 to 10? It's got to be somewhere around a 6 or 7. So I'm going to say somewhere 6 or 7. And then the records show it was a 3, or the record show it was a 10. Review your medical records for those types of things. Now, don't get overwhelmed. Don't think you have to memorize all that stuff. A perfectly acceptable answer would be, I'm not sure what number I put on it then. I just remember that it was bad, or that it wasn't that bad, or whatever. That's just an example. And we could go on for hours, so we're not going to do that today. But let me give you another example of peeling the onion or squeezing the orange. When someone talks about they are in pain, remember there's all different ways to describe pain. And the way I perceive pain and the way you perceive pain are going to be different, right? Because every body is different. But you have to figure out and explain truthfully how it impacted your activities of daily living. Because everybody says they have pain. It's not persuasive. What do I mean by activities of daily living? Everything you do in a day. Start from waking up, getting out of bed, whatever your morning routine is. So going to the bathroom, is it showering or shaving, or in a case of, women shave too. These are the kinds of examples you have to use, right? Like for some, and I'll give you some examples with women. And I don't want you to make anything up. These are just examples of how I've had some of my clients explain the way their life was affected. Shaving their legs was difficult because they couldn't bend. Doing their hair, putting their hair up in a bun. These are things I don't do. So right? But if you're a woman who are putting on a bra, these are some of the simple things women do every day, or some women do regularly, that may be affected. Now, if that's not your story, don't say it. It's just an example. Cooking. What do I mean by cooking? Well, bending down to get a pot, reaching over your head to get a pot, standing at the kitchen, the stove, washing dishes, shopping, going to the grocery store, driving, sitting at a desk, using the computer, on and on, right? Everyone's day is different, right? I don't think I need to insult your intelligence by going through all the things you do in a day, but you literally should think about, what do I do in a day that's the same every day or most days? What do I like to do for hobbies? Do I like to garden? Do I like to go for walks? Was that affected ever? Is it still affected now? If you have a dog and you like to walk with your dog or hike with your dog, maybe that was affected. Or if you like to garden, or if you like to dance, or hey, a lot of people just go to work and come home and eat and watch TV and go to bed and then repeat the next day. So don't make stuff up, but think about the way it affected your life, because the more things that are truthful that you can explain, the better your case becomes. And again, I cannot stress this enough, because I've had clients in the past hear me say that and think I want them to make stuff up. And I've had clients get caught in lies saying that they do things that they don't do. I had a client saying that he played basketball. And then so the lawyer started peeling the onion about playing basketball. Where did you play? Who did you play with? What were their names? And he couldn't answer any of those questions. And so we all knew he was full of baloney. And that hurt his case. And so I must have said, tell the truth a lot today. I think you get the theme. Because this is really, especially in the case where there's not a big, we're talking specifically about a car crash case where there's not a real dispute as to who's at fault. I don't want you to gloss over how that crash happened, what you remember. And listen, if you had a crash that was minor fender bender, that's fine. Don't make it more than it is. On the other hand, if you had a crash where your vehicle rolled over or you were hit really hard and you were scared, that's the time to tell that story is at your deposition. Not every car crash looks, when you look at the photographs, bad, but that doesn't mean the person wasn't hurt. And not every car crash where the photographs look bad means the person is hurt. So you have to really bring us back to that moment, because only you were there, and explain what the force felt like and what you did. And those are the types of questions that peel the onion about the crash. Where were you going? What time did you have to be there? How familiar were you with the road? When did you first see the other vehicle? These are just typical questions that a lawyer would ask. And this is a good place to say, generally speaking, when it comes to distance or time, be very careful about what you say. Example, I can't do it here because we're on video, but if I were to, and I do this all the time in my conference room, I'll say, how big do you think this conference room is from one end to the other? About half of my clients will take a look and say the number that is actually pretty accurate. The other half are just off by a lot. So what I tell all my clients is when someone asks you to estimate distance, for example, how far was the other car before you saw it? Or how fast was it going? If you don't know, that's a perfectly fine answer. You say a number, you better darn well be right about that number. So this may not be the case here, but if you're stopped, for example, and behind a car, and they say, well, how far was the distance between the front of your car and the car in front of you? And you say a number, it's got to be accurate. So it's always best when you're giving numbers for distance or speed or time to say, I would estimate this amount. Because then if you're off, you already told them you were estimating it. But on the other hand, if you just aren't sure, that's perfectly fine. You could say something like, I'm not sure how much distance there was between me and the other car, but it appeared to be, for example, a safe distance. There was definitely space between me and the other car, if that's true. So don't get caught in this, what I consider potentially a trap, even though it's not meant to be a trap. It's an innocent question. It's an honest question that every lawyer should ask. When did you first see the other car? Or how long were you stopped at the red light before you turned green? Or anything that says speed or time. You got to make sure that you're estimating it unless you know for sure. That's another question they'll ask. How fast, if you were moving at the time of the crash, how fast were you driving? Well, unless you were looking at your speedometer, do you really know for sure? So if you say a number, you got to have some rational basis for getting there. And it's okay to say, I don't know how fast I was going. And you don't need to be defensive in saying, but I know I wasn't speeding. But, I don't know. I'm not sure. If you're coming off an exit ramp and you think you're going 15 or 20 or 30 miles an hour, say that I estimate somewhere between 15 and 25 or whatever the number is. Same thing with questions about what was the speed limit on the road in a car crash case. If you know, you know. If you don't, you don't. These are what I call simple questions that people ruin their case over. When you start getting into things that may not even be relevant to your case or that important to your case, whether you know or don't know the answer, because remember, we have the police report, so we know what the speed limit was. And some facts, none of those other things matter. But what I call it is death by paper cuts. If you start making stuff up, guessing, God forbid, lie, these are all what I call paper cuts. One paper cut hurts a little bit, but it's not going to hurt you. Too many paper cuts, you're going to bleed out. And it's a graphic example, but that's why every question is so important, and every word or every response to every question is so important. All right, there are, and so that the chapter, I call them chapters. Picture a book. Picture your lawsuit being a story made for TV or the movies. This is going to be the beginning part, and most lawyers follow this format. Some lawyers jump around, and I think the lawyers that jump around are either not organized or they're trying to throw you off so you're not too comfortable, because most lawyers tell their clients this is sort of the format. So the client's ready for it. All of a sudden, they ask a question out of order. The client goes, wait a second, I was expecting you to ask me background questions or questions about the crash. Why are you asking me questions about my medical condition? So it doesn't necessarily have to be in this order, but here's what should put you at ease. When you tell the truth, it's easy to remember. Don't sweat this deposition. They're going to ask you questions and you either know the answer or you don't. It's that simple. So whether they ask you the questions in the order I'm giving you or they mix it up, who cares? That's up to them. But most lawyers will start with some background questions. We already talked about that. There's no background question I can imagine you shouldn't be able to answer. But if there is something you're worried about or concerned about, address it with me, address it with your lawyer ahead of time. Then typically questions about the incident. Even in a case where like a clear cut, the car crash isn't your fault case, you still have to spend time thinking about that. So that's an important part of the case because that sets the stage, right? For everything that happens afterwards. If you're hurt from a car crash, you better darn well remember things like the force of the collision and what happened, if you can remember. Sometimes people can't. And then there's a series of questions that just track, well, what did you do that day after the crash? Where did you first go for treatment? What was bothering you when you first went for treatment? What did you tell the doctor? Why did you choose that doctor? What did your treatment consist of? Did you see any other doctors? Did the treatment help you? How so? Now, these are questions that I've spent a lot of time talking about today. You have to peel that onion, you have to squeeze that orange, because these are the questions that turn you from a number, from a person making a claim to an insurance company for money, to a human being who through no fault of her own was injured. And as a result of someone doing something reckless or careless or negligently, it had real impact on their life. And only you can answer those questions in a manner that's truthful and let them say, okay, this is real. This really affected this person. And she was able to articulate that. And we believe her. She was polite. She was respectful. She didn't lose her patience. She was thoughtful. When she didn't understand a question, she asked for it to be restated in a different way. She gave answers that were consistent with what the records supported. She didn't exaggerate, but she was able to elaborate. They're going to write that report up and go, you better settle this case. She's believable. She made a good appearance physically. She was prepared. She must have spent time with her lawyer. And we think she's honest. It's not BS. Then all of a sudden, it's much easier to settle the case for an amount of money that's truly fair. There are two questions that they ask almost always at the end of every deposition. They sound very, very similar. So I'm going to ask the two questions first, and then I'll go back and discuss the difference. The first question is there anything that you claim that you can no longer do as a result of the incidents alleged in your complaint? In other words, as a result of the car crash or whatever the incident is. Is there anything you claim you can no longer do? That's typically the first of two questions they'll ask. And you almost ask that question first. The second question is there anything that you can claim has been impacted, your ability to do has been lessened, that you believe is related to the incident alleged in your lawsuit, the car crash or whatever the incident is? Even though I do this preparation with all my clients and I tell them those two questions are going to be asked, and I explain to them the difference if they don't get it, they half of them at least still answer that first question by explaining their limitations. The distinction is very clear, but it is subtle. And this is why it's so important to listen to not just these two questions, but every question. The first question basically says, is there something you can no longer do at all as a result of this car crash? Most clients, for most cases, answer that question truthfully, no. Some clients answer it truthfully, yes. And then if you answer it yes, they'll say, well, what can you no longer do as a result of this car crash? And then they'll peel the onion and ask some follow-ups. Well, did a doctor tell you you can no longer do that? So I'll give you an example of a client. I'll give you two examples. I have one client. She rides a motorcycle. She was badly hurt in an incident where she had to have her lumbar, her lower back, fused. The doctor told her, you should no longer ride a motorcycle because the suspension is different and you feel the road when you hit a bump differently. And my concern is that if you hit too big of a bump or too many bumps over time, the fusion will become unstable. You'll worsen your injury, may need additional surgery. She can no longer ride a motorcycle on her own doctor's advice. It's supported by medical evidence. And that, for her, made her claim even stronger because she had a doctor say you can no longer do this, and there was evidence that she did it pretty regularly. I had another client, he worked construction, and he also had a back injury. Common injuries in our back and neck often. And he was no longer able to work in construction. Similar reasons, different, but close enough for this example. And had to take a job working at a convenience store at about half of the money he was making on construction. Doctor actually told him that. Can no longer work jobs where you have to lift heavy things and climb and bend and stoop. So he had to take a job that was less physical. And that helped him in a couple different ways, because obviously his income was reduced and there was medical evidence to support that he had to change careers. He didn't have a high education, so he wasn't able to do a white collar job. He had to take a job in a convenience store, paying much less than perhaps if he was able to work a white collar job. And also, obviously, it impacted his activities of daily living. So unless you have something like that, and it's typically where a doctor has told you you can no longer do it, then the answer to that question, is there anything you claim you can no longer do, should be no. The second question is where 100% of my clients have to say yes, because it's true, and so they do, which is, how has your life been impacted? I should say 100, about 95%. Every once in a while, there's a client who actually gets back to the way they were before the incident. And this is important. On the day of the incident, the car crash, in a car crash case or some other injury, your baseline was whatever it was. After that car crash, your condition, your baseline went down. And then you experienced all these symptoms as a result of that trauma of the car crash, right? You needed treatment, therapy, medicine, and it affected you for a period of time. Eventually, you're released from medical treatment. And the question then becomes, did you get back to the way you were before the incident? To that baseline that you were before the incident. Now, if the answer is yes, that's great. We don't want to see anyone have a permanent injury. And so in that case, the claim is for the time period that you weren't back to that baseline. Could be weeks, could be months, it could be even a couple of years. But that's rare. Though typically those cases settle and don't end up in lawsuits. So in the case of a lawsuit, my experience is almost all of those cases, somebody has some residual impairment, some permanent impairment or disability as determined by a doctor that impacts them some way. And by the way, I just want to go put a pin in that for a second and go backwards. We talked about your activities of daily living, and I started waking up and using the bathroom and showering and going and cooking breakfast and going to work and your hobbies. I neglected to talk about sleeping. Depending on how many hours you sleep a day, if you sleep 8 hours a day, which is generally considered the recommended amount, a third of your life is spent sleeping. Not everybody who's my client who has injured themselves can have a full 8 hours of restful sleep. And when that happens, it's very, very important. Of course, hopefully they've shared that with their doctor, and that's in the medical records, but it's important to talk about how the sleep was affected. Even if it was just a temporary period of time, closer in time to when the incident happened, and then it eventually got better, or if it still lingers. Because the other lawyer is going to always peel the onion and ask you, well, for example, if a client says, I'm in pain every day or almost every day, the lawyer is going to say, how many hours a day? And that's when, again, pain is one of those weird things to talk about because it can be described so many ways and everybody's pain is different. So some of the peeling the onion questions that someone would ask is, well, how regularly do you have pain? Guaranteed you'll be asked that question if you're claiming you still have pain today. You gotta estimate that. I know unless you're keeping a diary on when you have pain, you know, you got to be able to put some rational estimate to that. How often do you have it? And whatever it is, the answer is it is. They'll want you to describe the pain using some sort of adjective, like I told you before, sharp, stabbing, dull, throbbing, or whatever other way you would describe it. On a scale of 0 to 10, 0 being no pain, 10 being the worst pain ever. When you get it, how bad is it? Is there anything you can do to make that pain less? What is that? And then how long does that take? So typically it's people will say things like, I'll take medicine, and they'll ask you, is it prescription medicine or not prescription medicine? And then if it's not, you know, who prescribes it if it's prescription? And if it's over the counter, they're going to want to know. And this is where sometimes my clients, I feel like, might be trying to help themselves by not being honest. They'll say something like, well, I take Aleve or Advil. Well, those are two different things. And it's possible they might take Aleve or Advil. But Aleve, Advil, and Tylenol, 3 brand names, are 3 completely different drugs. And so if you use all 3 of them, that's fine. They're probably going to want to know, well, when do you use Tylenol versus when do you use, and I don't mean 3 different brands, 3 different drugs. Tylenol is something called acetaminophen. Tylenol is a type of drug that is not just called something different. It looks, the components of the drug are different than ibuprofen, different than aspirin, different than Aleve. This is how clients screw themselves. This is how clients, the lawyer knows the client's making it up. In a little stupid thing like trying to make the case better by saying I take Aleve, Tylenol, and Advil, as if they're interchangeably the same thing, is a way that the client hurts her credibility. To tell the truth, again. But when you take medicine, does it help? So how long, when you have that pain, you know, does it last? Sometimes people say I have to get up and stretch, or I have to take a hot shower, or whatever. How long does it last? It's critically important. If you're still claiming years after an incident like a car crash, you still have pain, you better be able to explain the frequency, what brings that pain on, what you can do, if anything, to alleviate it, and how it impacts your activities of daily living. Probably always also going to ask you, why haven't you gone to the doctor recently? Or when's the last time you went to a doctor for that? You should have an answer for that. Typically, I see in my practice when clients don't go to the doctor after a period of years, it's because the doctor told them there's nothing else I can do home stretches, home exercises, take something over the counter, a muscle relaxant or a pain reliever, hot shower, stretch, whatever. So that's important because this is that area where you already know, oftentimes lawyers ask this question. It's one of the very last things they ask you. People start to let their guard down. Now they're talking about things they can no longer enjoy the same amount. Remember, the first one is things you can no longer do at all, whether a doctor told you or not. The second one is there anything you do less, or that when you do it causes you discomfort? And this, for most clients who have a permanent impairment, is a yes. So now you have to be able to truthfully explain what that is. It is always good to elaborate and explain it. It is never good to exaggerate. So I don't want to belabor that point, but if you say yes to that question, you got to be able to explain what it is. So typically I'll see things like sitting for long periods of time bother me. Okay, peel that onion. How long is a long period of time? Now remember, your deposition is going to go for a good hour, hour and a half, 2 hours, maybe more with an interpreter. If you've sat there like this without moving for 2 hours and then say sitting for 15 minutes hurts my back, you're going to look like you're a liar. So you have to be conscious of everything. Just sitting here today, my back hurts. That's an honest answer. So always look to help them understand your situation without just throwing out something that you think helps you. All right. But that's important. And that's usually one of the last questions. If after you're done asking the questions, I'm sorry, let me say that again. If after the other lawyer is done asking you the questions, and then it's my turn to ask questions, I may say, let's take a break. The purpose for that break is merely to ask you, is there anything that you think you said that you want me to clarify or ask some follow-up questions to? Don't feel compelled to say yes. I'm listening carefully. If I feel that you did a good job, I'll tell you, I'll say, I don't think there's anything I want to ask. Is there something you think you want me to ask you? On the other hand, I may have a few clarification questions to ask you. And if I need to do that, I'll tell you, hey, I want to ask you a few clarification questions. That's pretty much it. It's both simple and complicated at the same time. It's simple because you just merely have to understand the question and give an honest response. It's complicated because you want to give a thoughtful response that helps people understand who you are. So you go from being a claim number to a human who's really impacted. I hope that this explanation of depositions, what a deposition is and how it works will help you. There is one final thing that we're not going to do with an ASL interpreter, but I want to tell you that you have the right to do, but I would advise against it. We have the right to read and sign the deposition transcript. Let me restate that. You have the right to read and sign the deposition transcript. What this means is that you have an opportunity to review the transcript to see if you believe that the court reporter, that is the person who transcribed the questions and answers, accurately transcribed it. These court reporters are very good, highly trained. The companies that we use in Connecticut, almost without fail, never get it wrong, with the exception of maybe some typos or something, or if someone interrupts or talks over the other person. The reason I don't recommend that you read and sign it in this case is because if you're reading standard American English is impacted because of being deaf, for example, or someone doesn't read well, then it makes no sense to read and sign it. I'm not allowed to make the corrections. It's for you. So 9 out of 10 of my clients choose not to read and sign, even the ones who think they're very good readers, because they know they did this deposition preparation, they understood the questions, they gave a thoughtful, honest response. And so they're not worried about if there's a typo, because the typos don't matter. So I'm advising you to waive your right to read and sign. I would probably advise any person that is deaf who has a American English reading comprehension issue to do that as well. But we can talk about that more. You should talk about that more with your attorney if you have any questions. So that's it. I'm going to turn the recording off. If you have any other questions, please get those to me, get them to your lawyer, because it's important that all of your questions be answered before your deposition.